Hey everybody, Brian Parker here with a great new video. We just did a question and answer last Friday, and someone raised a question about their Discover Bank being sued on a Discover card, but a Capital One attorney showed up and sort of didn't know what was going on. All our educated members do, and that's where we fill that 10% void, meaning up to 9 times out of 10 cases get defaulted or settled badly and quickly. There's only 10% where someone educated comes through and really makes the other side work. So we're going to make the other side work today with using their own documents against them, but also using somebody else's documents against them. So if you're being sued by Capital One on a Discover card, the point that was made on our question and answer on Friday was the fact that I think it was May 2025, Discover Bank and Capital One, it isn't a merger, but the Capital One bought all the Discover debt. That's always going to go wrong somewhere because you have this transfer of millions of debts and you have securitization involved, as I'm about to show you. That's all about leverage. So let's look at this. So on their website, Discover Bank puts up the following, Shazam. What's happening to my card member agreement? It's all about the agreement. Remember, when you're being sued, even if it's an old debt buyer case, someone says, we have your contract. Your card member agreement and any other agreements are now between you and Capital One. This agreement and your account are governed by applicable federal law and the laws of the Commonwealth of Virginia. So if you know anything about Cap One, that's where their governing law provision has, this is what the substantive law must rest upon, comes out of all their contracts. Well, Discover Bank doesn't say that. So they're pushing the responsibility and changing the terms of the contract, and then you're being sued on a contract they're here claiming, it's not us, it's all them. So that's the beginning of a huge door you're going to open to win or use leverage. I guess you're leveraging the door. So when you are writing an answer at any time, I don't want you to put admit, deny, simple this, simple that. You want to create a power-packed problem Parker lawsuit. And I ask you, when you are writing a lawsuit or even a counter affidavit, you think of the word leverage. How does this give me leverage in the lawsuit against me? So you can turn it on them. Leverage meaning I can leverage how badly they're doing to a better settlement. So from here on out, never look at it as an answer, look at it as leverage. When you're writing, think, how is this going to give me leverage? So a Capital One lawsuit over a defaulted Discover originated debt is going to present real golden opportunities for you. So they didn't lend you the money, Discover did. And now they're coming in and saying, nah, we owe the debt. Good luck with that. You got to have a burden of proof. And they just made their burden very onerous. So let's look at how we're going to attack this. Shazam. First, lack of standing. It's a broken record about the broken chain of title. This is really a debt buyer opportunity. You can say, where is the legal proof that specifically the Discover Bank of mine with my account number has traveled to Cap One? Remember how that's going to go too. As I get ahead of myself, they get the debt, they securitize it, and you default. It's supposed to go back to Discover to sue, but now Cap One came in after you defaulted. So it's going to go like this, zigzag, zigzag. Ain't no way they're proving that. But you got to prove that unfortunately, the burden sort of rests on you to educate the court. So you got to hit them with a motion. I would ask myself, if my client wanted me to do the best move, I'd go, hey man, we're going to do a motion for summary dismissal because they can't prove they own the debt. They're going to have the wrong agreement. Now, normally in a creditor lawsuit, they will attach a copy of the agreement and act on that. So one of our arguments is that's not the real thing, governing law provision, etc. Now they're going to be copying a copy of something they got. It's not going to be the real thing. So you want to file a motion for summary saying they don't own this debt, or as I always say, file, or in the alternative, it's called a motion for more definite statement in most states. Say, Judge, if you're not going to let me dismiss, make them provide a validly assigned debt. So you're asking for a chain of custody. It's a debt buy case. Show me the contract, the assignment, the proof that Cap One bought my Discover Bank. As I'm saying this, I'm thinking, show me the facts. You know, they have that fox in that car commercial. It literally is that. Show me that this wasn't damaged. Show this is the original title. Show me this is all the real stuff. So I'm going to get into an area that I hate, not hate, but let me just say this. Shazam, Discover's arbitration clause. I don't like arbitration. There are times to go there, and I've got a video, Shazam, on if you have to go to arbitration, here's how you should play it, right? But this is an upset the apple cart move, an upset the apple cart move. So while I don't like arbitration, I love me some making some problems and being a problem parker. So I want you in a power move to ask for the cardholder agreements. So you can probably arbitrate this case. So here's the sneaky thing. Courts love arbitration. Get it off my docket, right? So they're going to join you and go, yeah, show us the agreement. He wants to arbitrate. She wants to arbitrate. Well, that just is your bigger picture as far as your motion for summary disposition. They won't have the original agreement that you need to have signed to arbitrate. So it puts in the head they don't have the stuff. Their internal account purchase is not going to include your debt, your agreement specifically. So the tactic is file a motion to compel arbitration based on the Discover agreement that you don't have, that Cap One can't be depending on. So you're upsetting the apple cart even if you do or don't want arbitration. Editor, I'm asking, it says editor here, so I just repeated. Editor, put up, no personal relationship with Capital One. If your client never had an account with Cap One, they never received, here we go, TILA disclosures or the billing rights directly from Cap One. That means something. You know, I just did that great video on the Fair Credit Billing Act. There it is. Go check it out. It's going to mean something now. Should mean something anyway. I got it. I work hard for this stuff. So, and under 1692E2, this, or any kind of E, this is really a misrepresentation. Cap One is misrepresenting the character and amount and legal status. So remember that video on FCBA. And the point is, you never agreed to borrow from Cap One. That matters. It's like a stranger saying you owe them money from someone else's loan. It literally is there. So number 4, possibility of discharge or compromised debt. If Cap One acquired charge-off Discover accounts, they may lack interest or fee rights unless clearly authorized in the assignment. Remember, I just did the video on Ocwen, Booz and Glover versus Ocwen, 11th Circuit, where I showed you that a convenience fee that we all click on to make our payment online could be an FDCPA violation if they're collecting a debt. And here's the key under 1692F1, if it's not authorized in the agreement. I just read you at the beginning that Discover Bank saying, here, you take the agreement, it's all with Cap One now, and that's what everybody does when they sell debt. Here, you take this. I bet it's a without recourse type of sale too. So Cap One may be seeking fees that the original agreement that is long gone does not authorize. So upset the apple cart here, folks. Under FDCPA 1692 F1, that was that Ocwen case, remember the 11th Circuit case? It's illegal if a debt collector attempts to collect any amount that expressly authorized by the agreement or permitted by law. So is Cap One a debt collector? If your debt is defaulted and they're collecting a debt and they're suing upon it, they're not servicing it like the Henson versus Santander case says. You're just a servicer if you're maintaining a relationship with the customer. This is about suing you on a debt that you don't have a relationship with the company suing you. So they can't collect what they weren't assigned, and if they're seeking interest and fees beyond the actual agreement, they have to prove they have the right to do that, or you have a FDCPA violation against them. And also, it's likely that the attorney put, we are debt collectors. Anything you say will be used for that purpose of collecting a debt. They can't say then, we're not collecting a debt. It literally says that. So number 5, this is a debt buying relationship 2. Capital One likely, Shazam on 5, Capital One likely bought Discover debt in bulk. Of course it did. They bought the whole thing, like billions. That means they only have spreadsheet level debt. You will have so much fun just saying to the Capital One attorney, yeah, show me where my debt was transferred from Discover to the securitization, who then assigned it back to Discover before the sale, and then it went to Cap One, who probably securitized that, but they didn't have, yada, yada, yada. It's a mess. So if they're going to sue you, they better show up with honoring the burden of proof and not a spreadsheet. Demand the real evidence and watch the case fall apart. I always write these flashy things, but I don't know if you're impressed. But number 6, I hope you're impressed by this, because it's a strong argument all on its own as far as leverage goes to get the debt down to a good settlement amount. Securitization means Discover may not have ever owned the debt when it sold it. I think it's more than likely, right? Discover securitizes most credit card receivables. If this account was sold into a securitization before default, as number 6 should say up there, Cap One bought nothing. So if you get into litigation, you can demand a copy of the pooling and service agreement. That is the lifeblood of every securitization. There's stuff in there they don't want you to know. I've tried to get a hold of those, and it's hard work. And remember, the harder they push, the more you want it, because they don't want you to have it. So schedule of loans assigned to the trust, they won't have yours. Service agreements, good luck who's servicing that. And there's something, a lot of this stuff I do my research. Repurchases or reversion document. I don't want you to get too deep on that, because that's heading into the actual sale and it gets to be a mess. So your litigation argument is a standing argument, all right? They sold a debt, or they claim they do, that was defaulted before or after, definitely after it was securitized. And now Cap One's come along saying, yeah, we own it. Oh yeah, how come? Because we said so, and usually 9 out of 10 of these just default, so we don't have to prove it. Reason? That's not a reason. So you come in, you're the strong 10%, and we're trying to expand that 10%. So let's put this up. 11 USC 541D, the rule in a nutshell: property in which the debtor holds as of the commencement of the case only legal title and not an equitable interest becomes, I'm going to get to what this means, becomes property of the estate only to the extent of debtor's legal title to such property, but not to the extent of any equitable interest in such property that the debtor does not hold. It means if Discover sold the receivable into a securitized trust, 99.9% Ivory Snow it did, it no longer holds the equitable beneficial interest in that account. It might service the debt back when, but it can't sell or assign it again, because the true ownership lies with, help me out here, who's it lie with? The trust, that's right. So any later assignment, this hand assignment, is void or voidable, likely void, and we've talked about what void versus voidable means. So you have a standing attack. In your answer, which I will provide with this video, I'm going to give you an answer, a standard answer, incorporating all I just said, for you to add your law and your facts against whatever they're arguing. I'm trying to make a template that we all can use. It'll talk about 1692A, let's put it all there, Shazam. It'll include a counterclaim, and also you can incorporate this into your answer, which I will. 1692E2A seeks an amount not expressly authorized. Remember, if they're seeking fees and costs, the original agreement that they can't find or duplicate doesn't allow them to, that's a violation of F2, right? Seeking fees you weren't expressly allowed to do, that weren't in the agreement. 1692F1, that says you can't collect, that you have no agreement to be allowed to collect. 1692E8, which I love for me some FCRA, FDCPA component. It should not, this debt should not be on your credit report unless Cap One can prove they own it. So I'll include a great letter on this video to send Cap One to prove the sale of your specific debt. It's a validation request, but I'm going to incorporate for you this sale and merger to kind of jog what you want. I'm going to create that answer for you, a template answer. That's what we do on this website. We create a problem Parker template answer and all the forms. And don't forget, I got to do this. Parker GPT is coming to do all of this for you. Right now we got these great templates, which are just great, but all you need to do in a couple of weeks, you'll just go to the website and you'll go beep, boop, beep, boop, beep, boop, beep, boop, beep, and up will pop the answer. Up will pop that letter. Anything you want, any case you're fighting, whatever's on my website is going to, whatever's in this stupid brain is going to be in Parker GPT. Can I do that again with the little airplane? That we are going to fly sky high with KillDebt AI. You can't spell anxiety without AI, and we're going to end the anxiety of your debt situation, so you'll be able to fight them if they're sending you letters, fight them if they're sending you lawsuits, fight them if they've somehow got a judgment against it, and you can get it set aside. So you can do motions, and motions to set aside, discovery, motion to compel, motions for summary disposition or to dismiss, all in KillDebt AI. You just go beep, boop, beep, beep, beep. You with your information, up pops the thing you need. How do I know that? Because we started testing. We haven't gone to the beta testing. When we go to the beta testing, I'm going to invite 50 members or more. Anybody that's a member of the currently a member will be allowed to use KillDebt AI for free. And we're going to have to charge something when it goes live because it costs a ton of money to create. But there's a version, I don't know any of this, but there's an alpha version. An alpha version of the platform comes to me and Natalie, our wonderful website designer. So we are told to try to break it. And we've been trying to break it. And each time it comes back and kind of breaks us. How great is it? It's just really good. And it's going to make your life so much easier and take the AI anxiety out of your life and this creating a debt response. So look for, I'll also throw in some discovery requests on the pooling and servicing agreement that'll help you, and seeking from Cap One actual proof. I'll put a motion on there too. I'll put a motion up there for a more definite statement or a summary motion that, again, you'll have to incorporate with your facts and law, which you probably won't have to once the AI is coming. So also these great show notes that are from my brain to you. And I hope this was a great video capturing a new attack on a new situation that we can use to our benefit. Cap One claims to own your debt. Make them prove it. Thank you very much.